Yes.
Adjournment request, if any, from item number 1 to 8. From item number 9 to 17.
Yeah, please, Your Lordship. Lordship, I beg to mention item 12 of today's list. But
Yes.
Lordship, there's a joint there. Lordship, I'm appearing for the respondent. Lordship, I need 10 days accommodation, Lordship.
You are for the state.
No, Lordship, I'm for the respondent, Lordship.
Actually, you are for the respondent.
Yes, Lordship.
Yes, state.
My lord, I beg to
No,
mention
Lordship,
item.
state.
Oh, that's anyways.
In the
You
council.
have informed the.
Yes, Lordship, he is out of station, Lordship. That is
So 12 and 13 would go together, no?
12.
It's the
Lordship.
same matter.
Well,
I do not think your item is
Lordship, Amarendra Nath.
well with
Only
13 and 14.
13 and 14 are total. All right.
He won't well.
Well, as prayed for on behalf of the respondent and consented to by the appellant state, appellant/state, the matter is adjourned to. You want 10 days?
10 days, Lordship.
Yes.
my lord, I beg to mention item 11, my lord.
Yeah.
Due to personal difficulties with my senior, my lord, it may be taken up next week, my lord. Anything.
For the appellant,
My lord.
a request has been made on behalf of the appellant for an adjournment on grounds of personal difficulty. So let this matter come up for consideration. 2 weeks.
Obliged.
26-8.
May I please, Lordship? Lordship, with the consent of other side, I beg to mention item number 15, Lordships.
Yes.
It may be adjourned to Lordship.
Or
I am for the respondent,
you're for the respondent, you have informed the other side.
Lordship.
Same order with the consent. 2 weeks.
28-8. From item number 18 to 20. Adjournment request.
Wait, please, Your Lordship. With the consent of other side, I beg to mention item number 90 of the daily list.
2 weeks.
2 weeks, right?
2 weeks. As prayed.
Obliged, my lord.
21-8. Any other request?
Lordship, may I pray for listing of an read appeal, Your Lordship,
Yes, what is it?
on 4th.
What is this matter?
This is,
You are making a mention for getting a matter listed.
yes, Lordship.
What is this matter?
This is non-payment of pension, Your Lordship.
Non-payment of pension.
Yes.
You filed a writ petition,
Yeah, this is a read appeal, Your Lordship,
writ appeal.
against my writ
All
petition.
right, all right.
Appeal was
When
filed
did
by the
you file
authorities.
it? When did you file it?
That was filed long back, Your Lordship.
Why has it not been listed?
This should come for orders, Your Lordship.
Defects.
On the,
Are there defects in the filing?
no,
All.
it has been admitted, Your Lordship. It has been
Yes, next week.
admitted. But then, Your
Accepted.
Lordship.
All right, give your slip. We'll have it listed next week.
Daily list for orders. Item 1.
123 days. Notice. Notice. Both modes returnable 3 weeks. पूरा detail लिख देना. Or an. Yes, sir.
In the condonation application of when there is a delay of 123 days.
We said notice. Now, do we require your argument for IA notice?
Item 2 for admission.
Maybe also not. You
Yes.
can please say my. And your lordship, the elected person has been removed by that by exercising power under section 62, my lord, 111 as well as the rule 62. Now your lordship kindly see the imping orders in just direct. One day, my notice was issued on 30th. Next day, it was fixed for hearing, inquiry report, my appearance. Next day, my order was passed. Page, my lord, your lordship will find page 85, my lord. Page 85 is the order dated 2/7/25.
Yes.
Your
Take
lordship
the
will
order.
find.
Place
Yes,
the order.
yes. Whereas the chief executive officer Moigao has reported by letter number so and so, that is very important, my lord. Letter number 2/7/25, along with report of video. Thereafter, my lord, and secretary so and so, dated 26/6/25. and so order dated 26 so regarding information of minor marriage of so two persons, my lord. Whereas the matters were also examined through Sri Pramod Sharma, SCS Assistant Commissioner, Lahorighat, and as per his report submitted by data number 1st July, date of birth so time marriage, which is a matter of minor marriage. As per the report of Sri Pramod Sharma, Assistant Director, 1st July, date of birth of so is a matter of child marriage, my lord. Now, my question, my your lordship, kindly see, my lord, the rules say if there is a child marriage, my lord, the Panchayat Secretary is to inform the BDO.
Yes.
BDO is to report to the, my lord, next officer, my lord, District Commissioner, my lord, through the CEO. On 30th, my lord, I got a notice to appear next day, 1st July.
That's all right, Mr. Counsel. The difficulty is here
Hmm.
that the single judge is in CC know the matter.
But that is, my lord, we
You
only
have
for,
challenged- you have challenged the decision of the single judge, not
yes,
staying, not
only for the,
staying operation.
only for the purpose of interim, my lord. I'm not, my only for the purpose of interim, my lord.
No, we are not granting any time.
Only for the purpose of interim, my lord, your lordship, kindly see that
Have
only.
the matter decided, the seat shall remain vacant. Will we say that the seat shall remain vacant?
Yes, madam, that, madam.
Take it.
A time limit may be given, madam. If was
Do we
elected
give
member,
time
my lord.
to the honorable judges? We'll say as expeditious.
I lift your lordship, madam.
What is it?
Elected representative, madam, people will suffer, madam, nobody is represented.
Their lordships at page 120. Let the matter be listed again after 2 weeks.
That's-
Till the next date fixed, the respondent authority will not endeavor to fill up the book. That's
So,
all.
Take. But Mr. H.R.A. Chaudhary, learned senior advocate for the appellant, and Ms. Sharma. What is she? Government advocate, Assam. The appellant which page, the order?
that is 118, madam, your lordship will find operative part is 112,
No,
1020.
Page 85.
Oh, including the 85, madam. Single just order is madam 120. Operative part.
The appellant had contested the elections, had contested the panchayat election, had contested the ward election, the panchayat election 2025 from ward number 9 of Gaon Panchayat and was returned successful. She was declared the elected ward member by the Deputy Commissioner on 20th of May 2025. The first meeting of the Panchayat was to be convened on 23/6/2025. But because of the lack of quorate, the meeting was adjourned twice. In the meantime, it appears that the appellant was summoned by the Assistant Commissioner, Lahorighat, to appear before him with identity documents for the reason of an inquiry which had been initiated against the appellant relating to her eligibility for contesting the elections. The records reveal that perhaps the appellant had married while she was a minor. After the inquiry, she was disqualified and was removed from the post of ward member for the reason of her ineligibility of having breached the statutory law of statutory law against child marriage. The matter went before the learned single judge, who has issued notice to the parties and has fixed the case for hearing. The learned counsel for the appellant questions the decision of the learned single judge, whereas this appeal on the ground of the learned single judge not having passed an interim order allowing the appellant to retain her seat till the time the matter was finally decided. It was argued on behalf of the appellant that the balance of convenience and prima facie case was in favor of the appellant. We find from the records that though the appellant has been held to be disqualified / ineligible for contesting the panchayat elections, but the seat vacated by her has been kept vacant. In that view of the matter, we do not find any perversity in the decision of the learned single judge not granting any interim relief in the meanwhile. We therefore dispose of this appeal with the hope and trust that the matter pending before the learned single judge would be decided at the earliest, giving opportunity to all others to put up their case. The appeal stands disposed of.
Honorable, in the meantime, I may be allowed to function, my
Not at all.
Madam, people
law
will
has
be
to take
unrepresented, my
The
people
law
will be
has to take its
unrepresented.
course.
I got highest
Yes.
vote in that
See,
year, madam.
See,
So popular
if the
candidate.
election commission, if the election commission would have sort of gone ahead and would have held elections, perhaps you had a case. Not now. The seat is to be kept vacant. Yes,
Madam, next item, same order, what number will be different, madam? What
Item
number?
three.
6.
changes, same set of advocates as well. Same
What
child
number,
marriage.
what number 6?
Same child marriage.
Same, madam.
Order number 6. All right,
Same.
all right.
Only what number 6 instead of 9.
This disqualification would have been introduced in the act only late.
Yes,
none
23,
yet.
madam.
That may be
23.
a ground.
And my
But
marriage
even-
took place long back, madam.
Even if you may not succeed on that ground.
No, madam, it has come
Because
in
law against child marriage was of 2006.
6.
Otherwise also, whether it is
No, that,
disqualification or not.
that
state-
removal part was not there, madam.
All right, yes,
That-
next. Next.
Supplementary list for
Supply-
admission,
supply
item
store.
21.
Wait, legal. Lord, this intra-court appeal is also directed against refusal of the learned single judge to give an interim order, my lord.
One second. Yes, give me 1 minute, Mr. Chaudhary.
Yes, my lord.
Your entire agreement was terminated.
Exactly,
Work order cancelled.
yes.
Why?
Now, my lord, what had happened? I offered 20, they call it TT, tanker truck.
Tanker trucks, yes.
Now, my lord, while submitting my tender, I made it very clear, out of these 20, 8 are already operating with other OMCs, marketing
That's right,
companies.
that's right.
And there is a requirement in the NIT that in respect of those TTs, I am supposed to give an NOC from the that company.
Company,
under
the oil
whom it is-
company which is,
Yes.
which has commissioned your trucks, yes.
And my lord, that NOC is to be given at the time of induction of the fleet, not along with the tender. And we did that. But here what had
Now, why
happened,
did you say this first one?
no, I'm coming to that, my lord. If your lordship would kindly come to page 161.
161 is what?
Yes, that's the relevant clause, my lord. General terms and conditions, clause 6.
Yes.
If your lordship would kindly come towards the bottom, clause 6. For tank truck under operation with any other oil company An unconditional no objection certificate is to be obtained from the concerned oil company for placing the same fully in the service of HPC, that is Hindustan Petroleum, against this tender.
And what is the charge against you? Why did they reopen?
No,
the
now
entire-
what had happened, my lord?
Hmm.
Now come to the facts of the case.
Hmm.
My lord, please come to page 336. This created a confusion, my lord.
It's 336.
Yes, an email was sent. এটা আমার তো মনে হয় জানো। Yes, yes. Now, this is a mail given by the corporation, my lord. Please note that deadline for submission of proper NOC is till 12 AM
Hmm.
of 30th March 2025.
Hmm.
And this is also issued at 11 AM of 30th March.
Hmm.
This prompted actually the petitioner is a consortium of, my lord, 9 persons, my lord.
Hmm.
Now, one of the partner, my lord, uploaded this document at page 337. This was not a requirement. We don't dispute that, my lord. Inadvertently, one of our partner uploaded this document.
Hmm.
This is to certify that Sarkar Enterprise in operation, the below listed TTs under transport contract under Indian Oil IOAD so and so, white lettered is which is valid till 28/2/26. These are the 4 trucks in respect of which this document was given, my lord. Now, towards bottom, IOCL confirms that the above mentioned TTs are released from the existing contract
Hmm.
of Messrs. Sarkar Enterprise.
Hmm.
Now, my lord, this is they checked up with the IOCL, my lord, and this was found to be not correct.
Why?
No, that's a fact, my lord.
Oh, then.
That is a fact.
Then.
No, my lord. Now, my lord.
No, Mr. Chaudhary.
Yes.
I was perhaps of the impression that this certificate was correct,
Ah.
but then it was belated or early.
No, we
Now,
gave
if this is a forced certificate,
Ah.
NOC, then you lose out on everything.
No, my lord, that's not the thing. That is where the case lies, my lord.
Yes, yes.
Please come to, my lord, clause number 45K.
45A of what?
45K, I'm just coming, my lord. Huh?
Page 78.
Page 78, my lord. Yes. No, actually, the action was disproportionate, my lord.
And that is something different. You know the law, no? They say in this world of competition, they say that one mistake and you're gone. That's what commerce law tells you. 1, we should not enter into that field. 2, if you are guilty of fraud, misrepresentation, or any wrong statement, everything, because fraud vitiates everything. Whether you intended to defraud is something different. But prima facie, that's the law. You have read
Yeah,
all the the entire trend of decisions. Are there.
Generally, yes, my lord. Perhaps in the facts of the case, an exception has to be carved out.
Disproportionate, we are not seeing it.
Please come
78.
to this clause
See,
K, my lord.
one, this is a law of very late origin.
Yeah.
Now, before that associated cement, we did not enter into that field. It was for the state to deal with people. It was the choice of the
In
state.
fact, my
But
lord,
because it was
Tata
one of the
Cellular.
right to employment,
Tata Cellular,
Tata Cellular, no, before Tata Cellular also,
Associated Cement.
Associated Cements. So we entered late. I mean, judiciary entered late, but then we must, Jagdish Mandal still holds true.
Yes,
Unless it is very required, keep your hands off. So the moment it is found that one of the facts uploaded
was-
by the tenderer
well,
is,
I'll make that submission,
anyway,
my lord.
78.
Even relying on Jagdish Mandal, I'll make that submission, my lord.
let's see.
K, please come to K.
Yes.
If any information provided
You're at
in the
78.
page 78, clause K, my lord, 45K of the ITB.
45K.
Yeah.
Yes.
If any information provided in the bid is found to be false and incorrect during techno-commercial evaluation, then corresponding trucks shall be liable to be rejected. I am on this, my lord.
Hmm.
So during the evaluation, they have found that information relating to these 4 are not correct. Therefore, my lord, that's why I'm saying the action was too disproportionate.
So the you,
Otherwise, my lord, the work order was issued to us. Letter of award was issued to us.
no. Mr. Chaudhary, you want us to deal with the interim order not having been passed, or we decide the petition, writ petition, we take it on ourselves, we decide it. What do you want? Tell us.
No, my lord, what I was trying to submit for your lordship's kind
wait,
consideration,
that-
one
that's-
aspect, my lord.
See, whoever,
Yes.
one of the members of the consortium,
Yes.
he uploads it. It's absolutely wrong document.
My lord,
No.
over enthusiasm actually.
I quite appreciate your
Yes.
argument that
Yes.
for not providing.
When
the
it was
correct-
not a requirement, he should have simply said, I am supposed to give it at the time of, and in fact, it was given. That document
That
is at
document would have been given, your.
page 340, my
You
lord.
would have all right, right kind of, no objections from oil companies with respect to DPs. But this certificate which you have uploaded is incorrect.
No,
On inquiry, it was found to be
no, my
incorrect.
lord, there are two aspects. Lordship will definitely, please come to
Mr.
page
Chaudhary,
340,
the
my
better
lord.
option would be to rest it out before the single judge, because we will, if we read this, if we do this, your single judge petition becomes infructuous.
In that case, lordship will make a request to the landed single judge to expedite the hearing, my lord.
That we shall.
Yes.
That we shall. That we shall. Normally, the practice which I adopted, I'll tell you what. In Patna, I hate to bring Patna all the time, but comparisons are not bad. Now, in Patna, for avoiding, it's one of the judgments of the Supreme Court that these commercial matters should be decided fast. Therefore, we made a change in the roster and in the system of filing, and all commercial matters were placed before the division bench.
Okay.
So all challenges would go to Supreme Court. But for matters which were taken up earlier before the change, no single judge used to hear the matter. And whenever it came before me in appeal, I mean, we used to close the petition, close the writ petition, decide the appeal straight away. In appeal, was many interim orders were challenged, no? So the better option is to rest there. Take the. The appellant slash Kaziranga Enterprise, a consortium of 9 partners participated in the bid against an e-tender floated by HPCL for transportation of bulk petroleum products by road from Guwahati IRD. The appellant was successful at both the stages and was granted the contract. After the granted the contract, the work order also was granted to him. However, later, on finding that the NOCs with respect to 4 of the tank trucks submitted by the appellant was not issued by the concerned oil company. The respondent HPCL thought it fit to cancel the agreement and the work order. After some arguments, Mr. K. Chaudhary, learned senior advocate, order. Stop. The termination order was challenged before the learned single judge, who is still in the season of the matter. Stop. Notices have been issued in that case, and the same is to be listed for final hearing. The present appeal has been filed for the reason, present appeal has been filed for the reason that the learned single judge did not grant any interim reprieve, allowing the appellant to continue with the operation till the time the matter was finally decided by the learned single judge. Stop. After some arguments, Mr. Chaudhary, learned senior advocate, seeks permission to withdraw this appeal with the liberty, withdraw this appeal with the liberty to approach the learned single judge and seek an early hearing of the case. Stop. We hope and trust that the learned single judge shall dispose of the writ petition of the appellant as expeditiously as possible.
And my learned friend will file the counter.
Obviously.
Deeply obliged.
The appeal stands disposed.
Daily list for hearing, item 4 to 6.
Give me a paper, one sheet of paper. How many persons have been convicted?
My lord, here, one, my lord,
Sheet
the
of
deaths and,
Note paper. Yes,
my lord, I am appearing for the one of the.
no, we are asking, just asking you.
One
number.
One.
person.
Only one.
person. Yes,
One.
and
Vikas
Vikas
Das.
Yes,
Vikas
Vikas
Das.
Das.
The other person, the other accused has been acquitted.
Acquitted.
All right. Vikas Das has filed an appeal.
Jail appeal, my lord.
Appeal 92 of 2019.
There are two jail appeals, your lordship.
Jail appeals. right?
Yes, I think,
Two appeal, my lord, he was convicted for the two different cases, my lord.
In two different cases.
Two different cases, nature and the modus operandi was same.
That shall be looked into differently.
Yes.
Now, with respect to one sessions trial,
Yes,
the conviction and sentence of death,
death.
this has been challenged by under which appeal?
My lord, the
We are
appeal.
not asking about reference, the appeal.
Appeal number.
Can be known. He's appealing the jail appeal.
No. Appeal number.
Oh, you're an amicus, Mr. Counsel.
My-
he is a
ma'am,
Vikas, he is-
What's your, this is a jail appeal.
Yes,
Can I have your name, please?
came Bora, my lord.
Ambor. All right, all right. So this is the jail appeal number. Give us the number.
Criminal appeal, my lord, J 92. my lord.
J is 92 of 2019.
My learned friend will be appearing as an amicus in both, since it's a in the dates reference, in terms of Anokilal case one,
No, don't,
yes,
don't bother about that.
lordship.
We are,
So he is an amicus, your lordship.
all right, he'll be appearing. Who are you appearing for?
I'm for the state, your lordship.
So therefore you will be justifying the judgment
Yes,
in the reference.
my lord.
All right. Yes,
And the appeal to your lordship. First, if the appeal succeeds, then the next step will come.
let's first deal with the appeal.
Yes.
I mean, would you
My lord,
would you argue in your own way, or would you respond to how the court would like you to?
my lord, as your lordship pleases, my lord, I'll like to, my lord, as per the course convenient, my lord, regarding the death sentence.
The practice which I follow is that
Yes.
I go from the beginning. Now, I would ask you to give me a brief resume
My lord,
of what is the case, when
Yes.
was the FIR lodged,
yes,
then all necessary details, how many
Yes.
witnesses examined,
my lord,
any witness for one particular point,
yes,
then medical evidence,
yes,
then we don't look at the judgment. We
definitely,
don't look at the judgment,
yes, yes,
only for the reasoning given for sentencing. The facts we reappreciate afresh.
later, yes,
Is that correct?
yes,
So you can begin this way.
yes. My lord, what happened, my lord? This accused, my lord,
Say the appellant.
appellant, my lord. So he was initially, my lord, in a CCTV footage,
No, let's have the FIR first.
my lord. FIR at page 1, my lord. Page in Page 51, page 4.
Yes.
I have the honor to inform you that yesterday, that is on 10/7/18.
This has been lodged by whom?
By one Santiram Patar, he is the railway, my lord, police, RPF, my lord, GRPF. Yes, and next.
Yes, Jitu Mipun, Mariani GRPS. Yes.
I will not inform you that on yesterday, that on
Yes.
10/7/18, in the down Rangya Express in the coach number SLR D 050706, some unknown culprits committed murder a female after committing rape, which was reported on the duty guard of the train.
Not
It is in the date. Mr. Bora, you are reading in the appeal or date paper? There are two paper books, my love.
criminal appeal
Yes,
like
sir.
2 or 114.
Date reference, I'm from reading from date reference 4/19.
No, you read from the records of criminal appeal.
92 over page 4.
Anyway, if the records are same, we will take it from the reference record.
92 part 1,
92 part.
92 part 1,
No, it is again reference.
page 4.
92. 1 second. 1 second, we will have the registry, modified to the way in which I am.
It to 92 is it? To take.
References of the state. Anyway, you refer from the reference only, reference documents. Let's just hold on for a minute. I'll be sure. And I'm putting that reference number 4/2009.
Yes, ma'am.
This is the reference. 4. Yes. Huh. Let's have the FIR.
Page 4, my love. It was lost by one Santi Ram Pator. I have honored to inform you that yesterday, that on 10/7/18, in the down Rangya Express in the coach number so and so, some unknown culprits committed murder of a female after committed rape, which was reported on duty guard of the train. So accordingly, my lord, GRPS case number 0618 under section 302(376 that has been registered on 11/7/18.
Yes.
So thereafter, my lord, after the recovery of the dead body in the platform, it was taken to the platform. Thereafter, search was going on during that process. And coincidentally, these people are looking for the CCTV footage because at that time, when the train came back, whether the next day
CCTV footage
In
of the platform.
from the platform, who has entered in the
Murder had taken place inside the train.
inside the well, that particular buggy, but they are looking for the person, my lord, who were commuters basically.
Alright.
Next day, then suddenly they have found a suspicious person who was limping, was get down from the train, and he was limping basically, and he has crossed the train line, and he was carrying a bag. So that footage, but they couldn't identify the person. So from that footage, they have started searching. Next day again, they found that suspicious person loitering in the platform again. Then that person was apprehended, madam, on suspicion. Then when he was searched from his bag, one mobile phone, then one earring, and one jhumka, that has been recovered.
Clothes.
And some clothes. Then he was interrogated, my lord. Then he is confessed, my lord, before the police. That's a different issue. Then accordingly, from the mobile phone, then it's a broken mobile phone. Then in that day, they got another information that is similar kind of as offense, the on a previous days also taken place. Because there are two incidents in 2 days, similar. Two lady has been murdered, raped.
That's right. Proceed.
So initially they are investigating in the first case, which has happened on interrogation 10/7. So they were initially investigating the cases which has been already been registered. That is in a different police station. That is in Samaguri, nearby.
Can I have a copy of the charge sheet?
Yes, ma'am. Page one.
Charge sheet is on the other file, my lord.
Other file?
Appeal 114J.
269 এর পর আরম্ভ হচ্ছে নাকি?
Page,
Charge sheet, page 165.
কোন কোথায় গেল? একটু বেলেগ কোথায় গেল? No, it's a different question. আমরা ইয়ার করছি। It is going to source.
Nothing. প্রথম appeal on
It is. It is 362. 360, my lord.
360.
Part 2. It starts from 269 to
no, charge sheet we are finding at 165 in the criminal appeal number 114J.
In the second one, there is no.
it should be the other one probably lordship is looking for.
You tell us where it is.
In the paper book, my lord, part 2 paper book, the page starts from 269 to 437.
269 to 430.
437. In that particular 360 is the search, my lord.
Oh, these are Caesar lists.
Yes, at 360.
These are Caesar lists.
No, my lord. Charge sheet, my lord, 360. Death sentence reference 4, my lord. Which one?
Himoluguri, no?
360.
18.
Himoluguri GPS.
Himalaya.
Yes. The date of occurrence is
10, my lord.
10/7/18.
10/7.
10/7/2018. And this charge sheet has been submitted on 21/9.
21/9/18.
Read from para 16.1.
356.
So this would give us some fair idea.
Yes,
And then we'll just examine the charge and
Right.
thereafter we'll go through the evidence.
on 11/7/18, an FIR was lodged by the Santiram Patar, age 59 so station superintendent of Himaluguri railway station, NF railway, Shivsagar at Himaluguri GSPs to effect that on 10/7/18, some unknown culprits has committed murder of a female after committing rape on her in coach number so of down Tinsukia Rongya Express passenger train, which was reported on duty guard of train. Accordingly, a case, Simaliguri GRPS case number 6/18, under section 302, 376, 34, was registered and the case was endorsed to the Sub-Inspector Govindo Kolita, Himaluguri GRPS, for the investigation of the OC Simaliguri GRPS. Later on, case was endorsed to the Inspector Otul Gogoi, Inspector Railway Police Morioni, for investigation by an order issued by the Special Director General of Police Railway Assam, Guwahati White Memo number so and so. Prior to the registration of the case, the SI Govindo Kolita registered an unnatural death case, White Himaluguri GRPS UD case number 16/18, dated 10/7/18, on the basis of written information received from the station master Himoluguri railway station. In the course of investigation of the UT case, IO arranged the inquest over the dead body through Sri Ganesh Chandra Das, ACS Executive Magistrate, Nazira Subdivision, Shivsagar, and sent the dead body of the postmortem examination to the Shivsagar Civil Hospital. Some items recovered from the dead body were seized, seizure list number 1, at the Simaliguri police station junction by the IO. The deceased was identified as so-and-so. The late Vishnu Dev Kumar Niani, the so-and-so, Rupalim Hall, Tipkagar Town, PS District so-and-so, by her mother, Srimati Tara Devi, wife of so-and-so, Prasad, near Rupalim Cinema Hall, Hibakagar Town, PS District so-and-so. Postmortem examination of the dead body, IO arranged the videography of the examination procedure on being produced by the escorting constable so-and-so, Nayantaya, aged so-and-so, PS Samaliguri. IO seized the garments used by the deceased and the compact disc of the PM examination videography in presence of the witnesses. Seizure list number 2. After completion of the holding the PM examination, the dead body was handed over to the guardian. The seizure garment was sent to the FSL for examination with the other exhibits. The PM examination report of the deceased was collected by the IO, in which the medical and the health officer, Hibakagar Civil Hospital, opined that the cause of the death is due to the strangulation, which was ante-mortem in nature. In course of investigation of the case, IO visited the place of occurrence and it draws rough sketch map and the sum of the indices of the record statement of the witnesses available in the place of occurrence. In addition to recording the statement of the complainant of the case, Satyaram Patel, and who corroborated the gist of the FIR. IO had also recorded statement of the Srimati Tara Devi, mother of the deceased, under section 161 CRPC, and also sent her for the honorable court for recording the statement under section 164 CRPC. During the course of investigation, steps was taken to identify the culprits by observing the CCTV footage of railway station of the nearby area to collect the clue about the culprit. Accordingly, on 12/7/18, Tinsukia RPF staff apprehended a person after examination of CCTV footage of Tinsukia railway station, and IO, on receiving the information of apprehension of the person, immediately moved to Tinsukia railway station along with the Inspector Danda Horma, OC Shivsagar PS, brought the apprehended person, namely Sri Vikas Das, aged about 38 years, so-and-so PS District, Dibrugarh, Samaguri, seized CCTV footage of the Tinsukia railway station from the RPF officer, in which the photograph of the suspected accused was found. Seizure list number 3. The sustained interrogation of the apprehended person, he confessed the commission of the crime with one Bipin Pandey. IO had seized some items from the possession of the apprehended accused Vikas Das, including the stolen item of the deceased Radha Kumari, seizure number 4, and also seized the wearing garments of the accused Vikas Das through seized. In course of investigation, accused Vikas Das divulged some of the co-accused incident, namely Bipin Pandey, alias Pandit, aged 38 years, son of Keshav Pandey, Sanhanpura, Kathiana District, Muzaffarpur, Bihar, whose temporary address in so-and-so, Tinsukia. Accordingly, IO conducted search in the rented house of the Bipin Pandey on being led by the apprehended accused Vikas Das and seized some of the items of his house, seizure list number 4. On getting evidence of involvement of the accused Vikas Das, he was arrested and forwarded to the judicial custody on 13/7, it should be 7, my lord, 2018. Lordship marked the date 13/7/18 and brought him on the 5 days police custody throughout for interrogation. That's important, my lord. From 1913, he was in the police custody. During the investigation of the case, the co-accused Bipin Pandey was apprehended on the basis of the information received from the technical support of the Dibrugarh GRP staff and the Dibrugarh Police, Banipur Railway Station, Dibrugarh, brought him to the Himolaguri GRPS. After sustained interrogation, he confessed that he, along with the Vikas Das, committed murder of the victim after rape. Accordingly, Bipin Pandey was arrested and forwarded to the Honorable Court and brought him under 4 days police custody. I will also seized coach so-and-so down Rangya Dibrugarh Express in presence of the witnesses on being produced by the station superintendent Himolaguri Railway Station, seizure list 6. During investigation of the case, on the basis of the statement given by the arrested accused Vikas Das and the Bipin Pandey, IO arranged the recreation of the scene crime under the videography in presence of the executive magistrate and other witnesses during their police custody period. This is very important, during their police custody period. On 16/7/18, the process of recreation of the scene of the crime of the accused because Das in Kimoluguri police station was undertaken in presence of the Ganesh Das, executive magistrate, SDO civil of Najira and other witnesses. In the same way, the recreation scene of crime was also undertaken on 17/7/18, in which the accused Bipin Pandey had shown the commission of the crime in presence of the Sri Orup Barmikia, executive magistrate, Najira subdivision, Shivsagar. The whole procedure of the recreation of the scene crime was also videographed, and the pen drive containing the videograph along with the camera were seized under seizure list number 7. During investigation of the case, IO arranged one to collect the blood sample, hair sample, and pubic hair samples of the arrested accused person through the doctor of Shivsagar Civil Hospital after producing both the accused person, namely Vikas and the Bipin Pandey, before the doctor from the judicial custody, and they send the samples from the forensic examination of the director of the Forensic Science Laboratory, Assam, Kailipara, Guwahati. During the investigation, a joint team of Forensic Science Laboratory, Assam Guwahati Criminal Investigation Department, Assam, Guwahati officially visited the Himoluguri railway station and examined the compartment and the train in which the crime took place. On being shown by them, I collected some dry blood stain with hairs from the place of occurrence and also seized the item seizure list number 8. I had sent the items for the forensic examination. During the course of investigation, the forensic examination report of the Director of the Forensic Science, Assam, Kailipara, was collected and analyzed. In the report, Arup Mehta, Junior Science Officer, DNA Typing Unit, Director Forensic Science, Assam, Kailipara, Guwahati, mentioned that the DNA profile of semen's stain found in the brown color underwear owned by the deceased so-and-so, and the DNA profile found in the SMS Gamusa seized from the body of the deceased of the place of occurrence match with the DNA profile of the blood sample collected from the Vikas Das. Evidence of human during the course of investigation, it's also learned that both the arrested accused person has committed the rape and murder of the lady named so-and-so place, my lord, Assam, inside the same compartment of disabled person of so-and-so down over the Assam Express train on 11/7/2018. That is on the next table. So this case is on 10th. There's one more incident that is on 11. And the dead body was recovered of so-and-so at Morioni railway station in connection with the incident. Morioni GRPS case number 14/18, 302-376 registered and so-and-so. It's revealed that both the arrested accused person, Vikas Das and the Bipin Pandey, as habitual desperate criminals. During the course of investigation, it is established that the accused Vikas Das is 38 and so-and-so place is a cook by profession and boarded the down Dibrugarh Rengya Express passenger train Dibrugarh railway station compartment for the disabled person, which was next to the engine of the train. Co-accused Bipin Pandey alias Pandit, aged 38, so-and-so, Kanapura, so-and-so, Bihar, whose temporary address in so-and-so district, a driver by profession and a friend of accused Vikas Das, also boarded in the same compartment of the same train, Dibrugarh railway station. Both of them knew each other. Investigation establishes that the accused Vikas Das, accused number 1, and the associate accused Bipin Pandey, accused number 2, regularly contact each other, and on 10/7/18, both boarded on so-and-so compartment down Dibrugarh Rongya Express passenger train in Dibrugarh railway station. Victim so-and-so was boarded in the said compartment down so-and-so Rongya Express passenger train railway station on 10/7/18, and his mother came to the Shivsagar railway station along with the victim to see of her. During the boarding time, train mother of the victim, namely Tara Devi, observed a person near a door of so-and-so LSD compartment in which her daughter boarded. Except him, there was no person inside the compartment as observed by Tara Devi, but accused Bipin Pandey was hiding in the same compartment. While the train was running towards the Simoluguri railway station, both Vikas and Bipin Pandey, with an intention to rape her, tied the neck of the victim by the gamusa kept by the Vikas Das on the throat of the victim and was alone in the compartment, and both dragged her to the toilet of the compartment. Vikas Das then raped her inside the toilet, and that time victim died intensely. Then the Vikas Das also became Bipin Pandey go to the inside of the toilet and rape her, which he did accordingly. After the accused, Vikas Das took a mobile phone and the railway ticket of the victim, so-and-so, from the bag which was carrying. Both the accused person then got down from the so-and-so station while train stopped there, my lord. A few hours both moved to the Tinsukia by aboard upon express. After arriving at Tinsukia railway station, they dispersed. Next day on 11/7/18, both of them again met together and boarded aboard upon express Dibrugarh for the Tinsukia in some same Elsa compartment disabled person, in which a lady was also moving in the same compartment from the Dibrugarh. Both of them tied the neck of the lady inside the compartment near the Panitola by a gamusa and raped and murdered her, and they both got down from the Tinsukia railway station and disappeared. In connection with the incident of Moriani GRPS case number 14 of 18 and the 302-376 was registered on 11/7/18. This is established from the confessional statement of the accused, statement of the witnesses under section 161 and 164 CRPC, CCTV footage, recreation of the scene of crime under videography, post-mortem examination report, forensic examination report, and other material evidence. Thus, the investigation establishes that the confessional statement of the accused, statement of the witness recorded under 161 and 164 CRPC, CCTV footage, recreation of the scene of the crime under videography, post-mortem report, examination, forensic examination report, other material evidence. There is a prima facie a prosecutable case against the arrested accused person, Vikas and Bipin Pandey, who knew each other, willfully committed rape of the victim so-and-so inside the toilet of the compartment of the down Dibrugarh Rongya Express passenger. Thus, they committed the offense of so-and-so. Both arrested accused person and the Bipin Pandey know each other, and they willfully committed the murder of the victim girl, Radha Kumari, by strangulating her in a gamusa inside the compartment number so-and-so down so-and-so Dibrugarh Rongya Express passenger train. Thus, they committed an offense under section 302 IPC. Moreover, both the accused person, so-and-so, colluded with each other, committed the rape and murder of the victim girl, so-and-so, in the compartment down Dibrugarh Rongya Express passenger train in the furtherance of their common intention. Thus, they committed the rape, so-and-so. So this is the short script, my lord.
Now give us a brief description of the PWs.
My lord, basically, the PW 1 to 8 are the recovery.
1 to 8 are the
Recovered. They did the recovery of the dead body from in the station, my lord.
Now give us now, like, I would like you to tell us, PW1 is a hospital attendant
Yes,
who claims to have gone to Simalguri railway station,
yes.
and did he see the dead body?
Page 12. 10, sorry, ma'am. It starts from page 10, my lord. He is the hospital attendant, my lord. He went to the railway station, my lord.
That will not be important. Now come to PW2.
Yes, 2 also by the,
No, PW2 is a private person
yes,
who had boarded the train
yes,
and had seen somebody with the shoes on in the toilet.
yes.
Now read that deposition.
I saw the legs and the shoes through the half-open door.
Hmm.
This is a Safai Karmachari, my lord.
The Safai Kamchari.
Yes.
Hmm.
He saw the legs and the shoes through a half-open door. Immediately, I informed the matter to the RPF personnel platform. They advised me to inform the GRPF. Immediately, I informed the matter to the GRP. Police person arrived in the coach, brought down the dead body of the girl from the platform number 1. I saw one Phulam Gamucha, flower towel, on the neck of the dead body. I saw the some of the blood stain on the nose of the body, up so-and-so open. Subsequently, I heard the diseased girl was from the ship saga. So basically, that part.
Hmm.
Then the
Now
three,
come to the cross-examination.
crossed by the, on seeing the legs through the door, I did not enter the toilet. I was interrogated by the police after 3-4 days of the incident.
Hmm.
While giving the statement to the police, I have not stated that I saw some blood stain on the nose of the body. Her pants was half open. It was not a fact that I have disposed falsely. Crossed by defense by the other accused. I boarded the passenger bogie. When I boarded, there some other passengers also present in the bogie. I cannot recollect the name of the person whom I came to see of as was friend of mine. Avila. That's all.
Now three.
Three.
He is a constable, my lord, of RPF attached to that particular outpost, my lord. I was working as a constable RPF attached to the Simaliguri so-and-so post. Upon arrival of the train, one Koilas Bhaskar came to the
Right,
Simaliguri.
PW4, wherever it is important, I'll hold
Yes,
it, right?
yes.
Otherwise, no.
The same, my lord.
Hmm.
He is also 4 is not so important. The same narration.
Tea stall owner.
Tea stall owner.
No, just a
Same.
minute. Just a minute.
Yes.
PW9 में.
Just a minute. Don't be in a hurry. Now, can you show, this is with respect to the assessment of the forensic evidence. Can you show exhibit 1?
Yes.
The investigation appears to be strange here. Anyway, we'll see what is it.
268, my lord.
In paper 1, paper 2,
Paper 2. Not 2.
268.
Different paper. Paper book 1 or 2. 268 in paper book 1. 268. No, thank God.
Part 1.
No, sorry, my lord. It ended at 268, so I don't have the book. We have to pay for it. 268 100.
160, 160.
260 the papers, you know. That piece of
160, that's a point.
forensic,
Okay.
once
14,
exhibit
14, that's
160.
160.
We are below. Well, except 160 below. Exhibit 3 then, right?
For some reason, we are closing the live streaming for this hearing.
I can understand.
By order dated 20th of, by communication, by order dated 20th of May 2025. Such a proposal has been rejected by the Secretary to the Government of Assam, Finance bracket PRU Department. Mr. Chaudhary, learned senior advocate, seeks to bring the order referred to above on record and challenge the same by amending the prayer in the writ petition. For the aforesaid purpose, he seeks a short adjournment. Mr. H.K. Das, standing counsel for the Guwahati High Court, has again informed us, has also informed us that a communication has been made, the communication made by the Registrar General to the LR, which has been referred to by Sri Das, learned standing counsel for the High Court of Guwahati, has yet not been responded to. Acceding to the request of the of Mr. Chaudhary and senior advocate, the matter is, both the matters are adjourned to. I think give you 4 weeks.
Lord,
4th
in
of
the other
September.
case, it is system assistant. There are two cases.
Both the cases have been taken up together.
Yes.
Both the
4-9.
cases have been taken up together.
Deep problem. Much obliged.
Item number 9.
Yes,
But on last occasion, Lordship has directed us to obtain 2 instructions, below. I have received, below. I am furnishing a copy from from where the entire report of the one-man committee can be seen, below. And as well as the,
24/7/2025.
yes, below.
Put it on record, not like this.
Lordship, I have received it.
You have received it,
I'll-
so
I'll-
put it on record.
I'll put it. I have given a copy to my learned senior friend also. I'll put it on record. As regard the status report, Malab, they have instructed me to play for 1 week time.
Mr. Nath, senior government advocate, submits that he has received instructions only recently, which he shall put on affidavit by the next date.
Lordship.
Re-notify this case on. We give you 2 weeks.
Lordship. Okay.
21-8.
Problem.
Item number 10.
Yes,
That's it.
100% reservation reduced to 30% reservation. Correct? I remember correctly?
Lordship.
Is that the matter that you
That's it,
had
that's it,
argued?
that's it.
And you had shown to us the judgment by Justice B.S. Chauhan
Lordship.
that, but then now 100% is all right. That must go, but 30% is understandable.
Lordship.
What do you have to say to that?
Lordship, I leave it to you, Lordship.
लिखा था? हाँ, नाम लिखा था?
Lordship, some other districts are also there, Lordship. Surrounding districts, Lordship, Karbi-Alang, Nagaon, Sonitpur district, Lordship. Some districts are there, Lordship. They will be deprived. And Lordship, another thing, Lordship, people of Golaghat only will be, of the district Golaghat will also be deprived. If only the candidates registered in the employment exchange are considered, Lordship. That is the difficulty.
Employment exchange would be, that also, you're right. The very logic which prompted the Supreme Court to say that you have to refer the matter to you have to intimate the employment exchange of the area.
Intimation.
That's a must.
That's a must. Intimation is a must. That does not mean, Lordship.
That the post should be reserved. It
Lordship.
should be only through that.
Lordship.
Only the employment exchange is sponsored
Lordship,
people will be considered.
in that regard also, Lordship, I have enclosed the Lordship is Lordship the restrictions they cannot make, Lordship. Page 56, Lordship. It starts with a serial number 5, Lordship. It is the Employment Exchange Compulsory Notification of Vacancies Act 1959. That starts at page 53. And relevant parts starts from page 55 and 55 clause 4, Lordship. Subclause 4,
Page 55.
56, clause 4, subclause 4. It says nothing in subsection 1 and 2 shall be deemed to impose any obligation upon an employer to recruit any person through the employment exchange to fill any
Where are
vacancy
you reading,
merely
sir?
because
Where are you reading at page
what's
55?
page 56, if it's that's on page 55, clause 4. That is rule. Lordship, got it, Lordship. The Employment Exchange Compulsory Notification of Vacancies Act 1959. Page 55, clause 4. Subclause 4, Lordship. It clearly says, Lordship, that you have to notify the employment exchange, but does not mean that it should be filled from the employment exchange only.
What's your name?
And Bhagavati.
Heard Mr. Manoj Bhagavati.
Lordship.
Yes, what do you have to say? I did not ask you. Mr. Barua? Mr. J. Roy,
Yes,
you're
sir.
J. Roy.
My-
Yeah.
If your lordship permits, it can be clarified also by now. That employment exchange, my lord. So this can be clarified, my lord.
So you are with the Supreme Court.
No, no, no. What I mean to say that, my lord, that we actually, I've said that the purpose of NDZ and other things, your lordship, that we have.
No, you have said something else. That's not acceptable. What the grounds, what you have said, affidavit in reply,
Para 3 and para 5, my lord.
para 7.
Para 7.
That makes, that
No, the lordship may see my reply. It starts from page 70, my lord.
no, we are looking at the affidavit here,
My affidavit in reply, my lord.
83.
83.
Which one? My reply.
Petition 83.
The writ petition 83.
Lordship 83 is my reply.
That's your reply.
Yeah.
Your reply, let's see.
My reply is at my lord, page 70.
Which paragraph?
Paragraph 3, my lord. I said about NDZ, my lord, then the amendment we brought in, my lord, 7.1, 7.1.2, and then para 5, my lord. About the reservation.
All right. We have heard Sri.
Lordship, one thing, Lordship, I think Lordship ought to know, Lordship. This refinery, Lordship, Numoligarh Refinery Limited, was established for the upliftment of the people of Assam as well as Northeast, the whole of,
Assam Accord.
the whole
Yes,
of,
Assam Accord.
Assam Accord,
Assam
Lordship. As per Assam
All
Accord,
right.
Lordship.
Heard Mr. Manoj Bhagwati. We have heard Sri Manoj Bhagwati, learned advocate for the petitioner, and Mr. J. Roy, learned senior advocate for
Refinery, my lord.
the Numaligarh Refinery Limited, a public sector undertaking. The present petition questions the policy of Numaligarh Refinery Limited, hereinafter called NRL, whereby recruitment process, whereby the recruitment to the refinery, recruitment of people, recruitment in service of refinery is only through the employment exchange of Golaghat. The petitioner has challenged both the recruitment rules followed by NRL and the process initiated by it, as they are unconstitutional and violate fundamental rights under Article 14 and 16 of the Constitution, guaranteeing equality before law and equal opportunity in public employment. The grievance of the petitioner is that since 2004, the NRL has been restricting job advertisements for lower grade posts, that is grade 4 and 5, only to candidates sponsored by District Employment Exchange Golaghat, thereby excluding eligible job seekers from other parts of Assam. Until 2003, the recruitment in NRL was conducted through open advertisements, accessible to all eligible candidates across the state. Since 2004, a change has been made, which is arbitrary, discriminatory, and unconstitutional. This court has been informed that earlier, in the year 2021, a writ petition was filed by WPC number 7217 of 2021, challenging a notification dated notification of August 2021, where the NRL had called for candidates only through the Golaghat Employment Exchange. Even during the pendency of the case, the NRL continued with its recruitment process and issued selection orders. The only justification for the NRL is that it has its own recruitment rules for employees other than officers. rules, 7 of those set of rules permit the NRL to limit the recruitment to candidates sponsored by Golaghat Employment Exchange. The further justification for such a restrictive recruitment policy is what have I said? Is the peculiarity of the location and situs of NRL which falls in no development zone. Since NRL falls in no development zone, comma, it would be a kind of obligation on such public sector company to provide for means of livelihood for people in the district where the refinery is situated. Keeping that in mind, the board of directors of the company approved the amendment to the recruitment rules and provided for such restricted recruitment policy. What had gone in for such consideration? The consideration of the estimated population, the consideration of the population of Golaghat district, the declaration of no development zone in the area, and the lean manpower of NRL was factored in. It was also considered by the refinery that it was established as a result of a SAM Accord, which had emphasized on promotion of local employment alongside industrial development. The reservation for local candidates was thus for the purpose of upgrading the poverty, alleviating the poverty level of the local population for whom there would be little employment opportunities. The petitioner, however, the petitioners, however, have pointed out that way back in 1996, the Supreme Court, in Excise Superintendent Malkapatnam, Krishna, District AP versus KBN, Viseshwar Rao and others, 1996, 6 Supreme Court cases, 216. Had held that it is a matter of common knowledge that many candidates are unable to have their names sponsored by the employment exchange. Though their names may be registered, or they would be waiting to be registered in the employment exchange. Under such circumstance, if the choice of selection by a company is restricted to only such of the candidates whose names would be sponsored by such employment exchange, it would not be in consonance with the principles of fair play, justice, and equal opportunity. Many deserving candidates would then be deprived of the right to be considered for appointment to a post under the state. It was thus held that it is mandatory for the requisitioning authority / establishment to intimate the employment exchange, and the employment exchange should sponsor the names of candidates to the requisitioning departments for selection, strictly according to seniority and reservation as per requisition. In addition, it was observed, the appropriate department or undertaking or establishment should call for the names by publication in the newspapers having wider circulation, and also display on their office notice boards, or announce on radio, television, and employment news bulletins, and then consider the cases of all the candidates who have applied. The Supreme Court opined that if this procedure is adopted, fair play would be subserved. The equality of opportunity in matters of employment would then be available to all eligible candidates. All eligible candidates. It would be relevant in this context to refer to the employment exchanges compulsory notification of vacancies Act 1959 for short, the 1959 Act. Section 4 of the Act of 1959 referred to above mandates that the employer in every establishment in public sector in that state or area shall, before filling up any vacancy in any employment in that establishment, notify that vacancy to such employment exchanges as may be prescribed. However, it shall not be obligatory for any employer, for any establishment in the private sector, for any establishment in the public sector to recruit only those persons who would be sponsored by the employment exchange. A plain reading of Section 4 of the Act of 1959 in its entirety would suggest that the employer is under no obligation to recruit any person through employment exchange only. Thus, there be no statutory intendment, the employer should always care for providing equality of opportunity for all eligible candidates. In State of Orissa and another versus Mamta Mohanty, 2011, 3 SCC 436. The Supreme Court made a very pithy observation regarding restricting the employment only to persons sponsored by employment exchange. Even though initially it was thought that such method of employment would curb the menace of nepotism and corruption in public employment. However, later it was found that the more consistent that a practice more consistent with Article 16 would be to make the employment open for public at large. Public at large. Such views have been echoed in other judgments of the Supreme Court as well. Bracket refer to Delhi Development Horticulture Employees Union versus Delhi Administration, 1992, 4 SCC 99. State of Haryana versus Pyara Singh, 1992, 4 SCC 118. State of MP versus Muhammad Ibrahim, 2009, 15 SCC 214. 2014. On a holistic reading of all the aforementioned pronouncements of the Supreme Court, it appears that 100% selection 100% recruitment for employment exchange sponsored candidates would not muster the test of constitutionality. During the course of the argument, Mr. Bhagavati has informed this court that now the 100% reservation has been reduced to 30%. This also would not serve any purpose. We say so for the reason that if the recruitment process is open to all eligible candidates, it shall cater to the needs of the local population as well. It cannot be said with certainty that all persons of Golaghat or neighboring areas would have registered themselves with the employment exchange, semicolon, in which case they would not have an opportunity of applying for such, applying against such applying for the for their recruitment in the NRL. Even otherwise, the recruitment rules of NRL do not appear to have been statutorily made, do not appear to have any statutory value, for the reason that it does not indicate any cutoff date or any concrete policy decision. Under such circumstances, we are satisfied that any decision of the NRL to restrict the recruitment only to employment exchange sponsored candidates would be bad in law and would be unsustainable. This writ petition therefore is allowed with the direction to the NRL to open up the recruitment whenever it is made to all the eligible candidates and not restrict it to employment exchange sponsored candidates only. Petition is disposed of.
That's it.
Let's finish.
Yes. Item 13 and 14.
Item number 13 with 14, yes. What is the issue?
Lordship, the 13 and 14, Lordship, issue involves this common, they are disposed by common order, Lordship. The claim made in the OA was that they are entitled to grade pay of 4,600 with effect for 1/1/2006. Then the next to be 4,800 with 2008 on the account of first MSCP. And the next grade pay of 5,400.
Let's see the impugn order.
Lordship. Page 99, Lordship.
Page 99.
99.
Let's have it at page.
Page 114. Whether it is repeating we have done.
GST. What is GST? Yes.
Lordship, the tribunal lordship relied upon the Ernakulam full bench decision, lordship, and simply relying on that has passed the order.
So it does not remain only the judgment of Ernakulam bench. It was
Lordship.
approved by the High Court and then thereafter by the Supreme Court.
Lordship, that's
Any
true.
dispute regarding that?
Lordship, whether they are entitled, lordship will come to page.
No, whether there is any dispute regarding
Yes,
that.
lordship, because Kerala High Court has passed similar order setting aside the order of the tribunal that I have annexed, lordship. Annexure 12, lordship. Prior to that, I would like to take your lordship to page 136.
No, but forget about the judgments now. Tell us the issue.
Issue is lordship, they have claimed the great pay of 4,600
Hmm.
from 1/1/2006.
Hmm.
Next, they claim great pay of 4,800 with effect for 1/9/2008 as a result of first MSCP
Hmm.
and great pay of 5,400
Hmm.
from relevant date of the second MSCP. Now, the claim behind that is on the basis of Annexure 8, page 136.
Hmm.
Lordship, may kindly come to page 136.
Who appears for the respondent?
My lord, I am appearing for this.
For which, for Union of India?
I am for the Union of
He is
India.
for the
Union of India has preferred this writ petition, Lordship.
Gojan Mai. Respond
This
number?
issue is, my lord,
They are the
tabled to
respondent.
High Court, then Supreme Court, and Supreme Court dismissed the SLP on merit. And Ministry of Finance circular is totally in support of the petitioner, original applicant.
You have responded to this petition?
No, they have not filed yet.
File your response. Mr. M. Chanda.
Yes.
Mr. M. Chanda, an advocate for the respondent, submits that he shall be responding to this petition by the next day. 3 weeks.
Yes, let it come after 4 weeks, man.
4 weeks.
Obliged.
2/9, 2nd of September.
Obliged.
Item 16 and 17.
May I please, sir? May I please, sir? This matter was supposed to argue by advocate general lordship. He's some personal difficulty, he's left the court lordship. Little recommendation for the lordship only.
What time do you want?
If
You should have informed Mr. Chaudhary beforehand. You were sitting.
just now he has left the court because
No, my lord, this matter, they have taken time on several occasions, my lord. My lord, we are not in a position to initiate a contempt proceeding. I have not been reinstated. Now, in the contempt proceeding, they'll take a plea that writ appeal is pending. And my lord, the matter is pending.
No, writ appeal is pending. If there is no stay order, they can always proceed in
No, my
contempt.
lord, Supreme Court in one of the case says, my lord,
Only one case. Only one. Midnapur.
Midnapur.
Otherwise, if there is no stay order, single judges say, bring the stay order within 2 weeks or else contempt, we will proceed. Anyway, next week,
Next week.
lordship.
a prayer for adjournment has been made on account of unavailability of the learned advocate general presently. The other side is being represented by Mr. A. N. Chaudhary, learned senior. Re-notify on next Thursday.
Lordship, yes.
7/8.
Dif-
7/8. Item 18.
Yes.
Pursuant to disciplinary crossing, the petition was dismissed from service. Thereafter,
You were dismissed from service.
service.
You were a constable.
The constable, madam.
Okay.
I prefer a writ petition, madam. That was also dismissed, madam. Against that, I have come before Lordship, madam. The
Grounds.
page 204, madam, is the order, madam. It starts, madam.
Let's see the impugned judgment.
Yeah, madam, page 204, madam.
One. That's the. Yeah, yeah. No, 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 that's the rule.
Yes. My contention is that not only section 27(2), rule 27(2) of the CRPF rules it was violated,
What is that?
that rule is with regard to the procedure that is to be followed,
Tell us the procedure. CRPF rule.
Rule 27, that's the procedure the procedure for conducting a departmental inquiry shall be as follows. The substance of the acquisition shall be reduced to the form of writing, to the form of a written charge, which should be precise as possible. The charge shall be read out to the accused with a copy given to him at least 48 hours before the commencement of the inquiry. At the commencement of the inquiry, the accused shall be asked to enter a plea of guilty or not guilty, after which evidences necessary to establish the charge shall be let in. The evidences shall be material to the charge and may either be oral or documentary. If oral, it shall be direct. It shall be recorded by the officer conducting the inquiry himself in the presence of the accused. The accused shall be allowed to cross-examine the witnesses. When documents are relied upon in the charge, in the support of the charge, they shall be put in evidence as exhibits, and the accused shall, before he is called upon to make his defense, be allowed to inspect such. My lord,
You go out of the camp
my lord,
and not make yourself available.
my lord,
How would these rules be applied?
my lord, my lord. My submission
You
here,
have
will be,
only three things in your favor which we can consider.
my lord,
Number one, with respect to your having been intoxicated and misbehaved with an assistant commandant, there is no other medical proof
my lord,
that you were,
my lord,
that is not necessary.
my lord,
That would be necessary only in extreme cases.
my lord.
The eyewitnesses, the prosecution witnesses say that all you and your friends misbehaved.
My lord,
So that's good enough.
my lord,
It's not a criminal trial.
my lord.
Number two, you may have been acquitted because the rules of evidence in criminal trial, the principle is decided that's against all reasonable doubts. This is something else.
My lord,
These are two different requirements in the
My-
domestic proceedings.
my lord,
And police force, you need to be absolutely careful.
my lord.
We are not finding any good ground.
My lord, here, my lord, my lord, the disciplinary authority, my lord, he acted as a presenting officer, my lord, and he went to the extent of, my lord, asking leading questions, my lord. There's clear judgment of this on the.
Where have you said that?
Yes, my lord, my lord, that leading questions, lordship will find from the, my lord, the records, my lord, because they have, my lord, brought on record, my lord, my lord, the questions that were put, my lord. Lordship will, my lord, kindly turn to, my lord. My lord, lordship may kindly turn to, my lord, page 117, my lord, there are 2-3 documents I'll show, my lord, page 117, my lord. To start with, my lord. Now, my lord, the presenting officer, my lord, one of the first witness was examined, one R.D. Yadav, my lord. Now, lordship will see the questions that were asked, my lord. There was specifically, my lord.
Then ask the question.
Yes, madam.
Please read out the question.
Yes, my lord. Following questions were asked to R.D. Yadav in presence of Rajpal Singh, the departmental inquiry officer, by the departmental inquiry officer. When on 4/8/98, when OC sir asked Rakesh Rao, deputy commandant, had asked Constable Love Kumar to sit for medical research in the car, and he refused to sit. At the time, OC Rakesh Rao had forced him to sit. At that time, Love Kumar attacked OC Rakesh Rao by punching him. And at that time only, according to your statements, Constable Vijay Kumar ran towards the line and spread the rumor that OC had hit the Jawan and said, "What are you guys watching?" So after that, the provocative statements of the two Jawans who ran to.
What kind of question are you expecting? This is not leading to an answer.
My lord, lordship will see
You
my lord,
recognize that?
My
No, I did not. This doesn't lead you. These are
no,
not
lordship
leading
will,
questions.
lordship will see my lord, how my lord, my lord, this is one, my lord. There are, my lord, constable, my lord, second
No,
question.
Question provocative. I mean, you were provocating other people. You were spreading wrong information.
No, my lord, that is against another person, my lord, not against me, my lord.
We are not testing it on that.
My lord.
These are questions which cannot be called leading questions. No. These are the questions. Leading question.
My lord.
You know what leading question is?
My lord.
What is a leading question?
My lord, for example, my lord,
So,
on
forget an example. Come to the Evidence Act and see what is a leading question.
question number
Anyway,
2.
you will see it later.
My
But
lord.
these are no leading questions. These are fact-finding questions.
The constable, my lord, question number 2, my lord. Constable Rajpal and 3 companions. So and so, so and so, and so and so were under influence of alcohol. According to your statements, how can you say that? The behavior was indicating there were alcoholic influence, and smell of alcohol was coming from their mouth. According to your statements, 4 Jawan had entered OC's residence with an intent of attacking him, but not finding him, they went to his residence, entered his room, destroyed the personal belongings. Then, my lord, so far as my lord, Rakesh Rao's segment concerned, my lord,
No.
Rakesh Rao, my lord, initially made some.
Law you were showing.
My lord, my lord, Ram Lakhan, my lord, the Union of India was a Ram Lakhan, my lord. But it's a copy lady. Union of India versus Ram Lakhan Sharma, my lord, that is reported in 2018-7 SCC 670.
When were you dismissed?
My lord, long time back, 19.
25 years now.
1999. Well, initially, my lord, we went to the Allahabad court, my lord, where my lord was dismissed on the ground of limitation.
Nothing.
On ground of my lord being my lord not maintainable.
Order. Nothing, Mr. Council, dismissed.
My lord, this is a specific case, my lord, where my lord, the honorable court has held, my lord.
What will happen? What will we do? 25 years later,
My lord, some my lord relief in the sense of my lord, some notional benefits, my lord, in the sense of pension and all, my lord.
you have not worked. You are out in service for last
I understand,
25
my lord,
years.
but then lordship will see, my lord, this person has been removed, my lord, dismissed from service, my lord. My lord, by the presenting officer was acting as a judge, as a judge.
But stand, it's
Judge
very
is the
easy.
prosecutor.
It's very easy for us to dismiss it, but difficulty arises. But the other side also would be put to difficulty. No, not in this case, till next.
My lord, here is a case, my lord, where he was totally, my lord, the presenting officer was asking, was acting as a, my lord, judge as a prosecutor himself, my lord.
We have heard Mr. M. Datta Leonard Council for the, and Mr. B. Chakravarti. Yes, next.
Item 20.
Dismissed. Yes.
My lord, the appellant, he applied for a location of a liquor shop, my lord, in Lakhimpur district. Now, his application was rejected.
Okay.
Yes. Now,
Why are you so tentative, Mr. Chaudhary?
respond.
Mr. Chaudhary, why are you so tentative in your arguments? His application was rejected.
Yes.
So then what happened?
No, I'm sorry, my lord. That's correct. Yeah, it is the
You
respondent's
want to do
application.
it on some other date, we are agreeable to.
No, it's all right, my lord. Now, if a lordship kindly comes to the
No,
NI,
just tell me what happened actually.
actually, my lord, we are agreed by the order
Hmm.
of the learned single judge,
Hmm.
where cancellation of tender of the other side, my lord, was interfered with by the learned single judge, and learned single judge directed that his case should be considered. He did not comply with the tender requirement.
Oh, just give us 1 minute.
Yes. So, I don't know. Nineteen. Responsible. No, 213.
Yeah. Huh. Who are you?
I'm the qualified bidder.
And where is the?
If
you
a
are
lordship would
qualified
kindly come to page 213, Miller, the
No, no,
comparative statement.
paragraph of the judgment?
Okay. Please come to page number 263, Miller.
I look at it from the
Internal
certified-
page 13.
internal page 30.
Yes. Para 26. On a careful reading of serial number 18 and serial number 22 of the list of document, this court is of the view that there is no indication in the NIT that serial number 22 should supersede or prevail over serial number 18, read with Annexure C. In Maya Matthew, the Supreme Court held that when there are two sets of rules, the court should endeavor to apply a harmonious construction to the said
Why you
provision.
heard? Was this intervention was made at what stage?
At this stage, my lord, where my learned friend's bid was rejected. So he came
And
out.
by that time, you had succeeded.
I am already qualified. My lord, there were three bidders, the appellant, the respondent, and another one.
So how, there are many offline things, no? There are many stations, many licenses have to be issued.
Yes, yes. Amongst others, this was one of the license.
So
So
is
for a
he
particular locality.
be competing with you? That's the
Yes,
question.
now because of the learned single judge's odd judgment, my lord, his claim revives.
No, his claim may revive, but
Yes.
you would get license only for one shop, no?
One shot.
He would get license for another. There are many.
No,
There's
no.
only one license.
No, only because for this particular area, we
Were
have
you
three.
heard that time?
My lord.
Were you heard that time?
Yes.
You were
I
heard.
have no grievance on that. I'm not aggrieved by the order of the authority. I'm aggrieved by the order of the learned single judge, whereby the case of the writ petitioner has been upheld. According to us, it should not have been.
And what is the ground which he has taken?
Yes. Well, Lord, if your lordship would kindly come to learned single judge has considered only one ground. There are several grounds. Well, Lord, in fact, instead of giving a lease deed, the writ petitioner has given a notarized affidavit.
No,
Now, if your lordship kindly comes to page 90.
Rejection by the technical assessment committee.
Yes.
Was on what grounds?
Yes, page 213. This is the minutes of the proceedings, my lord.
Page 2 and 3.
Yes. Please come to serial number 7. That is the writ petitioner. And serial number 8 is the appellant. Towards the bottom of 213.
The writ petitioner is?
The writ petitioner is serial number 7, my lord. Srimanto Gogoi.
Srimanta Goi and appellant
And
is?
Dhubajyoti Saikia is the appellant. Kindly see, my lord, I am qualified. Now, in respect of writ petitioner, site plan not countersigned by executive engineer or assistant executive engineer of PWD, B, violation of point 22.3 of the bid document.
What is that bit of?
Yes, please come to page number 90, my lord, first.
Is 90.
90, yes. Serial number 12. Serial number 12, site information. My lord, this is the part of the first NIT. Initially, there were no sufficient bidder, therefore it was, the fresh NIT was issued. Site plan certified by an engineer.
That is ground number 1. Site plan not countersigned by executive
Yes.
engineer assistant. That's
Yes.
one.
Yes,
We are talking about violation of 22.3.
page 78, my lord. No, there is one more thing, my lord. Kindly see, in 12 only, landholding Jamabandi valid lease agreement with the owner of the premises. These also he did not qualify. Then please come to 78.
Page 78.
Now, this is regarding, my lord, trying to influence. After having submitted bid, if somebody tries to influence, then he shall be disqualified. That is 22.3. Now, what the learned single judge did not
Where
note.
is the statement that he had tried to influence?
Lord, to be honest, my lord, we are not pressing much on that point. We are basically on the
You are
first point.
on the first point.
Yes, yes. Now, please come to page 97, my lord. Page 90, what I have placed is the part of the first NIT. Please come to page 96, the second NIT. It was on 23rd of February 24, page 96. For details, after that box, my lord, please refer to previous bid document and follow the revised timeline as given below.
The second NI.
Second NI. Now at page 97, my lord, 22. Site plan duly signed by Assistant Executive Engineer. So, my lord, the earlier requirement has been qualified by, and earlier it was an engineer, now it is an Assistant Executive Engineer. And apparently, my lord, the site plan which has been submitted by the petitioner is signed by an engineer.
And what does he say, the judge?
Yes. Now please come to 264, my lord, 265 rather. I was reading that, let me complete it. In Maya Matthew, Supreme Court held that when there are two sets of
13 you had referred.
page 263, my lord.
Internal this.
Internal 30. In Maya Matthew, the Supreme Court held that when there are two sets of rule, this court should endeavor to apply a harmonious construction to this said provision. Similarly, in this case, a site plan can be certified under serial number 18 or 22 of the list of document when assistant engineer and AEE respectively, the rejection of the petitioner's technical bid only on the ground that the petitioner's site plan had been signed by AE and not by AEE is found to be arbitrary. Further, this court finds the requirement under serial number 18 of the list of document and Annexure C regarding the manner.
The single judge has quoted from Agmatel, NG projects, Mandal and
Yes, yes.
Yes, Boli. Yes, what you?
Your lordship will kindly see first,
No, answer this only.
my lord.
Answer
I'll answer this, my lord. The learned honorable single judge has categorically taken into consideration, my lord, two clauses. One in the first bid, page 88, your lordship will
say engineer was left open.
No, my lord. Annexure C, that is very important. Page 88 is Annexure C.
Page 88.
Page 88. Which page 88, Annexure C, it is the part of the first NIT, my lord. Now, page 88, page 90, my senior has read serial number 12, which is site plan certified by an engineer. Now, the page 96 is the new NIT, my lord, which between the two tables, your lordship will see, for details, please refer to the previous bid document and the following existing timeline as given below. Now, if your lordship turns to page 97, next page. Now, in serial number 18, it says Annexure C. Annexure C is that page 88. And 22 says site plan duly signed by Assistant Executive Engineer. The Honorable Single Judge has categorically held that the 18, whether 22 supersedes 18, there is no distinction in the NIT.
If there is a specific provision made, that shall have precedence over the other.
No, the documents which was
After all, these are the ways in which competition is eliminated and one person is selected.
no, the page 97 says both two things. One, Annexure C has to be followed. Again, 22 says site plan has to be followed. Both two things. There is an ambiguity in with these two clauses.
I don't think so.
Yes, because
D and E. This was C.
This was C. Page 88 is C. Serial number 12 is 88.
Checklist.
Checklist.
So that checklist is for others, but
No.
there is a specific provision, site plan duly signed.
Yes.
My lord. Now, the Honorable Single Judge has categorically followed the findings. Your lordship will kindly see page 263. The paragraph 25 first. Internal page 13. and paragraph 27, my lord, page 40.
And in contractual matters, no harmonious construction.
In fact, my lord, this is a NIT. My lord, in fact, this is an,
No construction is required.
I understand, my lord. My lord, this is an NIT for a wine shop, my lord. Where, my lord, the site plan, whether it is signed by an assistant engineer or an executive assistant engineer, would not be.
That depends upon the employer, the
Employer's perspective.
the
My lord,
person, the entity which floats the,
Tender.
it's the perspective.
My lord, my lord, when there is an ambiguity in the two conditions.
Assistant executive engineer is higher in post,
Yes.
Absolutely.
so they wanted more validity. We can't get into that.
No, yes, it's true. But your lordship, here, my lord, the overwhelming public interest would have been more because the respondent.
Wine
he-
shop, what public interest? It's your personal interest, you
No,
want license of license.
the appellant quoted 5 lakhs and he quoted 38 lakhs. There is a difference of 33 lakhs and therefore the
Price. Price for the state, that's no indicator.
no price, the respondent, the petitioner, he quoted 38 lakhs.
Even though you had been qualified, but with your lesser offer also, the government.
No, higher offer, I mean.
Higher offer. I mean,
Higher
lesser or
offer.
higher.
And
whatever
the
it is.
difference is of.
Higher offer, so you're giving more revenue.
My lord,
Then that is not always the consideration.
of course, the
Because
33
they
lakhs.
will see
the
whether
difference
you
of-
have that liquidity with you, whether you're
My
good,
lord, my lord,
whether you'll not misuse the license, many things.
well, in fact, my respectful submission, but the 2 grounds of rejection that is orchestrated, my lord. One first, my lord, that influencing the authority, wherein the affidavit was sought from by the honorable court from the officer against whom these allegations were made, my lord. He has made a categorical affidavit that no, he did not identify anyone. So that itself, that ground was rejected by the honorable single judge. The second ground, my lord, in this, my lord, I would like to rely on a judgment of our High Court, my lord, where it has been said that when there is an inconsistency between the 2 clauses and there is an ambiguity, my lord, that itself is an arbitrariness, my lord.
This doctrine will not apply.
I may be allowed to place that, my lord.
Yes.
Paragraph 16, my lord.
Read.
Paragraph 16. A notice inviting tender is the first step to initiate a process for settlement of a public contract or for distributing any form of the state largesse by tender system. It is an offer to the public soliciting participation of an eligible and willing members thereof in the process. Essentially, thereof, the terms and condition of such a notice have to be clear and intelligible to be essentially understood and not ambiguous, contingent, and misleading lest the very purpose of the process is lost. A notice inviting tender is to ensure competitive bids so as to enable the authorities concerned to select the best available tender suing the requirement on a consideration of all relevant factors. The exercise would be reduced to futility if the NIT conditions are indeterminate and obscure. The NIT condition to ensure that the process is fair and transparent are required to be strictly adhered to by the authorities as well as to the tenderer. In this scenario, if a tenderer is misled by while submitting his tender by an omission, inconsistency, or incoherence in the NIT condition, it would be destructive of the concept of fairness and reasonableness to reject his tender on account of any defect therein because of the above reasons. Reading the NIT with all its clause, I am of the view that it cannot be decisively held that it was reasonably ascertainable that a clearance certificate from so-and-so was a document to be mandatorily.
Here it is clearly ascertainable.
Hello.
That
Here
the
also.
site plan has to be signed.
Right.
Very petty ground, but Mr.
Kaushik.
Kaushik, the difficulty is that these are the grounds on which people are eliminated.
But here also, my lord, in the NIT, first NIT says that the site plan has to be set. Yes.
To
the maximum.
Yes.
You're absolutely correct in saying that this, suppose it were a private enterprise or, I mean, not a private enterprise, but something where the offer would have been too large, something, not a wine shop, but some construction work where you'd have agreed to offer very good price, lesser than the highest, lesser than the lowest. Perhaps one could have considered, but then the law today is that please keep your hands off. One ground, unless you are able to show malafides, unless you are able to show that there is nothing, I mean, there's total, what should I say? The words used by the Supreme Court is that if it is invested with malafides and
Grossly or
the process has been completely, thrown to the winds or completely irrational, unreasonable, and so on and so forth. Whether public interest is affected, which public interest is affected?
Well, it's a state largesse, my lord, where one is offering
State largesse
38 lakhs, choosing 5 lakhs.
for what? Or is spoiling the liver and kidney of people.
Res extra commercial.
Less extra commercial.
Yes, sir.
They know what is to be done. No interference.
So in my respectful submission, lord, the views which has been taken by the honorable single judge.
The time is 3:30. I'll put a laptop. We have heard Sri A. Chaudhary, learned senior advocate for the appellant, and Mr.
Be cautious.
Vedanta Kaushik, led counsel for the respondent / writ petition. The challenge in the present appeal is to the judgment dated so and so passed by a learned single judge of this court in WPC number 1681 of 2024, whereby the decision of the respondent authority to disqualify the respondent / writ petitioner has been interfered with and has been set aside. A direction has been issued to the state respondents to open the writ petitioner's writ petitioner / respondent number so and so financial bid and consider the same along with other valid bids in pursuance to the NIT. The appellant had come out successful in the bid. A bid was floated by the next paragraph. A bid was floated by the District Commissioner Excise Branch, Lakhimpur, through NIT dated 20th of December 2023 for grant of IMFL retail off license at various locations in Lakhimpur district. This NIT was withdrawn / cancelled because of lack of sufficient number of participants. A subsequent NIT was issued on February 23, 2024, in which the technical bid of the private respondent / writ petitioner was rejected on 2 grounds, namely that, which page 88?
213, Miller.
Page number?
213, Miller.
Unique. 213. Was rejected on the ground that the site plan offered by the respondent / writ petitioner was not countersigned by assistant executive engineer as was required under the NIT. And another and there was a violation of clause 22.3 of the bid document. Bid document. This was challenged by the respondent writ petitioner before the learned single judge on several grounds, but primarily on the ground that in the first NIT, a checklist had been provided which permitted the site plan to be countersigned by engineer without any specification of junior engineer or executive engineer or assistant executive. Stop. In the later NIT, similar checklist was issued, and for any clarification, the earlier NIT conditions were made referable. However, with respect to the counter signature of the site plan, it was specifically provided that it shall be countersigned by assistant executive engineer. The technical bid of the respondent / writ petitioner was countersigned by an engineer, by an assistant engineer, by an assistant engineer. The land counsel for the respondent has contested the present appeal. The land counsel for the respondent, the learned single judge found that this was not a mistake which was deliberate or would have gone to the very issue of the credibility of the bid of the respondent. And held that the list of documents in the bid papers, there was no indication that the requirement of getting the site plan countersigned by assistant executive engineer superseded the earlier requirement of it being countersigned by only an engineer. By only an engineer. The learned single judge, therefore, went for a harmonious construction of the conditions, of the bid conditions, namely of the first bid which was recalled and the second NIT which was being considered, and found the objection of the respondent, of the state respondents, of the state authority, of the respondent authority, and found the respondent to be too technical and harsh to be justified. But as such, a direction was issued to consider the technical, consider the bid of the respondent writ petitioner as well. This has aggrieved the appellant, another bidder who was successful on all counts, and now fears that he may be ousted from the competition with another competitor in the fray. He has submitted the submission on his behalf, of the appellant is that times without number, the Supreme Court has clarified that a decision relating to award of contract, that in a decision relating to award of contract, courts of law ought not to exercise power of judicial review or interfere on minor procedural aberration or error in assessment, or on the ground that prejudice to a tenderer is made out. The tenderer or a contractor with a grievance can always seek damages in a civil court. any attempt by unsuccessful tenderers with minor grievances, even wounded pride, or for that matter, business rivalry, ought not to be permitted to make mountain out of a molehill of some technical / procedural violation or some prejudice. The courts, before interfering in any decision-making process by the state authorities, must consider whether the process adopted or decision made by the authority is malified or intended to favor someone, or whether the process adopted or decision made is so arbitrary and irrational that the court would say that the decision that the court can say that the decision is absolutely unacceptable, or where public interest is affected. Stop. If the answers are in the negative, there should be no interference under Article 226 of the Constitution of India. Bracket refer to Jagdish Mandal versus State of Odisha and others, 2007, 14 SCC 517. Cartel Infotech Limited, Afcons Infrastructure Limited versus Nagpur Metro Rail Corporation Limited, 2016. 16 SCC 818. In the second NIT, it has specifically been stated. 97. It has been specifically stated in the second NIT, the documents to be submitted along with the technical bid was listed. The annexures C, D, and E of the earlier NIT was though made referable, but with respect to the counter signature of the site plan, a specific entry was made in the list of documents that it shall be signed by the assistant executive engineer. This could be for a purpose of lending more credibility to the site plan, or else the requirement would not have been changed in the second NIT. The law with respect to laying stress and accepting the specific provision with regard to any particular requirement is very clear. A specific requirement must have precedence over the general requirement. That is a non-derogant specificity. We will write it. उसमें Latin एक term है, लिख देना. Just try it. The on a perusal of the judgment impugned, we find that an effort was made unnecessarily to go for a harmonious construction of the provisions of the requirements under the 2 NIT, which was not required. In this day of competition, any fault on the part of a bidder could be fatal. The courts should keep its hands off such decisions, especially when it does not affect any public interest or is not reflective of any malefacts. For the aforenoted reason, we are not in agreement with the judgment of the learned single judge, which we deem it appropriate to set aside. We order accordingly. The appeal stands allowed.